Now, just obviously I'm dealing with the short form conditions of contract. Now, I have to say I differ from Martin slightly on this in that I like this contract. I know Martin doesn't. I actually do like this contract. I mean, it says exactly what it does. It does exactly what it says on the tin. It's short. It does actually quite a lot of what the main contract, sorry, that's probably bad language, the standard contract, if we call it that. It does a lot of what that does, but in a lot less pages, a lot less clauses, and a lot less words. I actually like it. The only thing is that, and I find people don't know this contract. They don't get their heads around the fact that they're dealing with this contract. More often than not, I see people haven't read the contract. So that's where you run into problems. It needs a lot more administration in some respects than the standard one, even though that kind of sounds like a contradiction in terms. But once you have all of that, then it's actually quite an easy contract to administer. The aim of today's talk, and I'm not going to take you through, you'll be glad to know I'm not going to take you through laboriously through all of the clauses in detail. What I've done is I've picked out, under the contract, I've picked out the clauses where claims arise and where contractors have rights. And we're going to go through those clauses. I'll show you how to make your claim, and then the important thing is tying all of the claims together and having essentially a paper trail all the way through the contract. That's really where contractors seem to fall down more than anything. When I'm giving this talk, it's going to sound like it's a horribly burdensome thing. You're all going to be sitting there going, I don't have time to be writing all these letters. I don't have anybody who has the time to be writing all of these letters. And what I'd say to you from the very outset is, you're all educated people. You can all read and you can all write. These letters are at most 6, 7, 8 lines long. Of course you can. So it's not the burdensome thing that everybody seems to think it is. It's not a huge document exercise. It's a very careful. If you manage the process very carefully, then you can administer these contracts very easily. So with that, I would say 9 out of 10 disputes that come to me, the problem is the EOR, and we can say that openly in this room, because I presume there's nobody acting in that capacity in this room. But 9 times out of 10, the problem is the EOR, and the problem is the relationship between the contractor and the EOR. You as the contractor have got to make it your business when you start this project. Get to know your EOR, get to know what makes him tick, get to know how he works, get to know what he likes. Go for a couple of pints with him, do whatever you need to do, but establish a relationship with the EOR. The number of times that I see disputes and I say, do you know, the whole problem in this dispute is that the contractor came in at the very start of this and tried to act the smart aleck with the EOR. Very often you have an EOR who can't handle the contractor, ironically enough, and more disputes are caused by a relationship breakdown between the contractor and the EOR, even more so than between the employer and the EOR, I find, because a lot of the times the employer is quite simply relying on the EOR. They will leave everything to the EOR, so if there's a breakdown in the relation between the EOR and the contractor, then that's where the disputes will happen. The standard contract is very prescribed in terms of communications. It's very prescribed in terms of how everything happens. You must submit your program. You must submit your regular monthly progress statements. All of these things. This contract isn't. This contract is very vague in that regard. So at the outset, if your EOR, an EOR should be at the outset setting out all of the sort of practicalities of how he wants the contract to work. But if he's not, then you as the contractor should be doing it. Make sure that you know, for example, if you're going to notify the EOR of something, is he a guy who walks around every day with an iPhone, gets emails, answers emails 2 minutes later? Is he a guy who sits at a desk and takes post, God forbid, with stamps on it? You need to know all of those things because they're going to be very important. You'll see as we go on, timelines become very important. If you're sending him a letter that's going to get there 2 days later, but it's outside the timeline, then you're finished. You need to make sure that at the outset you clarify all of these things, and you can't have it that, you know, you typically send him an email, but then the one crucial letter was sent by way of letter or something like that. Clarify all those things at the outset. And if you do, then you should have a lot less problems as you go along the way. Another critical thing to do is, which nobody does it bizarrely, and Don referred to it earlier, the contracts on the government website change. The conditions of contract which will apply to your contract are the ones on the website 10 days before the date of your contract. I could probably say that I've seen, again, I probably see 8 out of 10 cases come before me, nobody printed off the conditions of contract. So you don't know. Nobody knows what the relevant one is. So, you know, we all agree to work off. Now, it might not be important, but these contracts do actually change regularly. There may well be something that changed, which is critically important to you, but nobody has the contract printed off. So again, if you have an EOR who's not a terribly active EOR, not terribly good on the documents, you as the contractor need to make sure, just print off. It takes all of 2 seconds to go into the construction procurement website and print off the relevant contracts. So again, just make sure things like that are done. They all sound like very basic practical things, but they're the things that ultimately, when you come to dispute, are the very important things. Because trust me, when you do come before the lawyers and the conciliation. That's the sort of thing we're all looking for, and you can be sure we'll all have the proper contracts and we'll all have the ones that applied on the day. But if you don't have it, then it handicaps you straight away. So again, very simple but important. Now, just before I get into the clauses I want to deal with them specifically, as I said, contract administration in this is really key. The contract can be quite vague in places, which you can use to your advantage or your disadvantage. But again, if you have the proper administration done on the contract, then that you should be okay in it. Make sure everybody's working off the short form contracts. I mean, it defies belief how people do not even understand the conditions of contract they're working off. And I hate to say it, but EORs are not working off the short form contract. The number of times I get in a certificate of substantial completion, which is based on the model of the standard contract, as opposed to on the short form contract. You know, I'll get EORs telling me, oh, but I did sectional completion. There's no sectional completion in the short form contract, so it doesn't mean anything. So everybody needs to be working off the short form contract. Now, you're probably all sitting there going, hang on a second, this is the EOR's job, it's not our job. But what I'm saying to you is, you make sure that you're working off this contract, so that no matter what the EOR is doing, if you're working off this contract and you have the clauses that I'm going to tell you today foremost in your head, knowing that you need to act if something happens, then you know that you've properly administered the contract. And once you come to a dispute, if you come to a dispute, then you'll have all of the paperwork you need to make your claim. So, as I said, the employer's representative is key. We've said enough about that. Now, very, very, very important in these contracts, all of the risk and costs is with the contractors, and the price only increases in accordance with the terms of this contract. No other way. Now, I'm probably coming at this, which is no harm, because for the last 18 months, the Department of Education have come down a ton of bricks, which many of you I know are doing schools contracts, you'll know this, but they have come down. The cutbacks have come in, there's no more, the school gets their allocation of funding, and that is it. There's no more money. So we really are dealing with a situation. When I have a contractor coming to a school now looking for more money than was provided for in the original contract, it simply is not there. And I can tell you, I, on behalf of the schools, rely on every single clause in this contract to make sure that that contractor is not entitled to another cent. So sorry, I know that sounds terrible speaking to you and you probably want to lynch me, but that's how important it is that you get your administration in order. Because the one thing I can tell you is that if the contractor is entitled to an increase, then they will get their increase and they're entitled to it. Like, for example, in a school, and I don't want to keep harping back to the schools, but just because it's my particular area of experience, it probably makes sense. If a school comes to me and I can quite clearly see that the contractor is in fact entitled to an increase under that contract, I'll go to the department and I'll say to the department, this is an increase that they're entitled to under the contract, and they'll get it. Straight away they'll get it. There won't be any issue. But if the contractor doesn't have their written records and their claims made, then they're simply not entitled to it. So you'll see as we go along that'll become more important. Now, so as I say, you'll see now when we go into the claims, a claim letter must be sent for each and every claim, and it must be sent on time. If you don't get your claim in and get it in on time, you lose your rights. I'm going to come back to that when I'm dealing with a specific clause, but just very, very important, you do lose all your rights. So to get into the claims now, the claims can only arise in 5 situations. So it's not kind of the monster of a contract. It's not, that everybody thinks it is, because you really only have 5 specific clauses that you need to know. The contract is formed the day the letter of acceptance is sent. That's your contract date. You must be given access to site within 5 days of that, and you must commence working within 5 days. Now, you asked about this earlier actually in terms of time for completion. Under this contract, you must complete the works within the time for completion stated in the schedule. If you don't complete the works within the time for completion, LADs apply. It's not like in the standard contract where you're obliged to proceed regularly and diligently and all of that. These contracts, if you go by the letter of the law, you must complete within the time for completion. If not, LADs apply. Now, everybody operates on the assumption that local authorities don't apply LADs, and typically they don't, and Don said it earlier and he's quite right. I'll tell you where LADs come in very useful is when you're acting on behalf of the public authority, because I use LADs to bring down the contractor claims under the contract. So again, make sure that clause 2.7, as I'm going to take you through it now, make sure if you have all of your paperwork in order, I shouldn't be able to use LADs against you. But if you don't have it in order, that's when the LADs will come in, and they come in very handy in terms of reducing claims. So clause 2.7, just to go through it, provides that the EOR will extend the time for completion by an amount corresponding to any delay to the substantial completion of the works caused by any of the following and not resulting obviously from the contractors or contractors' personnel's acts or omissions, except as an unavoidable result of complying with this contract or the contractor's breach of this contract. So you're entitled to an extension of time for compensation events, which we'll deal with in detail later, loss of or damage to the works. And again, that's not defined under this contract. That's the extent of it. It is more defined under the standard contract, but it's not under this one. So again, you need to be quite careful in dealing with it. The weather event, which is your standard 1 in 10, which is dealt with in the capital works framework. Strikes or lockouts, which hopefully are a thing of the past. An order or other act of a court or public authority, so, God forbid if the HSA shut the site down or something. And then a failure or delay of a person other than the contractor or contractor's personnel to do what this contract says they will do. Now that last one is the one where most of these arise. If any of those things happen, you as the contractor, you need to get a claim in. The EOR, even though the contract says the EOR will extend time for completion. So yeah, you don't want to be in a situation where you're arguing in a conciliation that he was obliged to extend time for completion. But yet you find yourself in a situation where you haven't agreed. So he's saying, well, I'll allow you 3 days. You're saying, well, I was gone for 10 days. You've nothing on paper. If you haven't made your claim, then there's nothing there. So you as the contractor, as soon as something like that arises, if there's a weather event, whatever, whichever of them arises, you write your claim. You say what you need. So you say, it's probably snow is a bad example, but if it snowed for 6 days and you were gone for 6 days, immediately put in a letter to say that you need an extension of time for 6 days. The EOR will come back. If he says, no, you're only getting 2 days, then you have the Barney at that stage. But as I say, I see it all the time. People coming back to me, contractors going, no, we're entitled to 2 weeks extension of time. I go, but you've nothing on paper. The EOR says you're only getting 2 days. Contractors really scuppered in dealing with that situation because of nothing on paper. It's very, very simple to just have a claim in saying we need an extension of time of 6 days. If the EOR won't give it to you, and I'm going to show you at the end, I'm going to tie in how all the claims link back to each other. So if the EOR won't give you your 6 days and you really need your 6 days, that in itself becomes a claim. So as I said, I'll sort of tie it all in how you deal with them all.